All right, let's be on the record in case number 2018-CR685, captioned State of Kansas versus Gary Hall. Would the parties announce their appearances, please?
May it please the court, Karen Whitman for the state.
May it please the court, Mr. Hall appears in person via Zoom, along with his counsel, Gary Long.
All right. And as Mr. Long noted, we are here by video conference today, given the pandemic. And Mr. Hall, my understanding in talking to Mr. Long is you've had a chance to discuss this with him. And while you have a right to physically appear in person in court, my understanding is that you and he wish to waive that right today and proceed with this plea hearing through video conference. Is that correct?
That's correct.
All righty. Thank you, Mr. Hall. All right. I would ask the parties, I didn't get a chance to look. Has preliminary hearing been waived by both parties at this time?
I do not show that that has occurred.
Okay. Well, we better take care of that. Mr. Hall, you have a right to have a hearing that's called a preliminary hearing. At that hearing, the state would have to put on enough evidence for a judge to find that there was probable cause that the crime was committed and probable cause that you committed that crime. You have a right to that hearing, and your decision either to hold that or not hold it would be completely separate and distinct from whether you decide to plea or not. Now, if you decided to waive your preliminary hearing today and go forward with this plea, and for some reason in the middle of the hearing or anything like that, you decided not to plea, you couldn't take back your waiver of preliminary hearing if that's what you wanted to do. Do you have any questions for either me or Mr. Long about that today?
No.
All right, and do you want to waive your right to a preliminary hearing today?
I want to do what's most expedient. I want to get it over with.
All right. Mr. Long, are you satisfied with, or on behalf of your client, in advising him to waive his preliminary hearing today?
Yes, Your Honor. We've reviewed the discovery in the case together, as well as prepared a plea petition, and are asking the court to waive preliminary hearing so we can proceed with the plea hearing.
Okay. So, Mr. Hall, what your lawyer is saying is he's advising you to waive your preliminary hearing. And what you told me is you want to move this in the most efficient manner possible. And that would involve a waiver of preliminary hearing. But you need to either specifically decide that you want to waive that hearing or that you want to have that hearing. So I'll ask you again, do you want to waive your preliminary hearing today?
Yes.
All right, thank you, sir. And Ms. Whitman, on behalf of the state, do you waive preliminary hearing as well?
Yes, Judge.
All right. I will find that the parties have freely and voluntarily waived their right to a preliminary hearing, and find there is probable cause for the charges as they are. I will enter for the time being a plea of not guilty on behalf of the defendant and bind him over for trial. Now, given that, Mr. Hall, my understanding is that you want to go forward and change your plea today from one of not guilty to guilty. Is that correct?
Yes, as far as yes.
Okay, so to
I'm
do
sorry,
that,
could you speak up a little bit?
Yes.
Mr. Hall.
all right. To do that, I need to ask you some questions. And in order to do that, I need to place you under oath. So could you raise your right hand for me, please? And my court reporter will administer the oath.
Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
All right. Now, Mr. Hall, like I said, I'm going to ask you some of these questions. At any time, if you don't understand what I'm asking you, I want you to tell me that so we can talk about it to make sure that you understand before you answer, okay? I don't want you just guessing at an answer. Is that okay?
Yes.
All right. At any time, if you want to talk to Mr. Long in private, I can do what's called send you to a room so that you and he can converse without us here. And if you wanted to do that, I would let you do it. You just need to let me know and we'll make that happen, okay?
Okay,
All right. Now, Mr. Hall, how much formal education have you had?
about 13 years.
All right. You read and write okay?
Yes,
All right. As you sit here today, I know that you're in the jail, but I need to ask you, are you under the influence of any alcohol or drugs or prescription medicine that might cloud your mind and keep you from understanding what's going on?
no,
Feel like your mind's clear today and you understand what you're charged with?
yes,
All right. You understand that you're not required to change your plea from not guilty to guilty. If you decided not to plead not guilty, you would have an absolute right to a trial by a jury in this case. Do you understand that?
yes,
At that trial, the state would have to put on enough evidence to prove you guilty beyond a reasonable doubt. You wouldn't have to prove anything yourself. Do you understand that?
yes,
In addition, your attorney would have the right to confront and cross-examine all the witnesses the state called, call any witnesses on your behalf. And if they didn't want to come to court, he could use the subpoena power of the court to make them come. Do you understand all that?
yes,
At that trial, you would have a right to testify, but you would also have a right not to testify. And if you decided in consulting with Mr. Long that you didn't want to testify, the state couldn't use that against you. In other words, Miss Whitman couldn't get up and argue to the jury, well, ladies and gentlemen, he must be guilty because he didn't tell you his side of it. Do you understand that?
yes,
If you went to trial and you were found guilty, you would have a right to appeal that conviction to a Kansas appellate court. And if you couldn't afford an attorney for that appeal, one would be appointed to assist you. Do you understand that?
yes,
All right. If you enter your plea of guilty today, you're going to be giving up all of those rights. There's not going to be a trial to either a court or a jury. Do you understand that?
yes,
Any questions about any of these rights that we went over?
no,
All right. And do you want to go forward with this guilty plea today?
yes,
All right. I have received, Mr. Hall, a copy of the plea petition. I'm going to put it up here on the screen. Okay, tell me if you can't see this. All right. Now, when
Your Honor.
this got, pardon?
Just briefly for the record, given unique circumstances we're in, Mr. Hall and I met. Not only did he review the plea petition you're displaying, I also left a copy with him at the jail for his records as well.
Thank you. Now I'm going to go through this, Mr. Hall. I will tell you that when it scanned into the computer, 2 of the pages got switched. But other than that change, does this look like the document that you and Mr. Long went over?
Mhm. From what I can tell, yes, that's my signature.
I'm sorry, I need you
Okay.
to speak up, please.
I said, yes, that's my signature.
Thank
All
you.
right. So on this page, and that's the one that's out of order, that signature that right there that I'm showing, you put that there on that document, right?
Yes, I did.
Okay. And Mr. Long, you signed it as well,
Yes, Your Honor.
Ms. Whitman?
Yes,
All right. Now, Mr. Hall, as I read this plea petition, it says that this is the agreement, that you're going to plead to count 1 of the information, which is DUI third offense, that the parties are going to recommend to the court a sentence of 1 year in jail and suspend all but 120 days of that sentence. Then when you get out of jail, they're going to recommend that I put you on 1 year of post-imprisonment supervision. There are going to be costs in this case, including the minimum fine of $1,750. You'll need to attend a bad impact panel within 60 days of getting out of jail. You're going to have to get a substance abuse evaluation, follow the recommendations, and you can only drive when properly licensed and insured and with an ignition interlock in your vehicle. I'm not sure what this next sentence exactly means, but In other words, you're gonna have to have that ignition interlock in your vehicle, in any vehicle that you drive. You can't use any illegal drugs, and if you're prescribed any medication, you'll have to inform your supervising officer. Is that your understanding of the plea arrangement, Mr. Hall?
Yes,
Mr. Long, is that your understanding as well?
It is, Your Honor.
And Ms. Whitman?
Yes, Judge.
All right. Mr. Hall, do you have any questions? Now that I've read that and I have it up here on the screen, do you have any questions about anything in that plea agreement?
no,
All right. Now you understand agreements as to sentencing, the court's going to listen to those closely and take in all the facts. And I'm going to consider their agreement in deciding what your sentence should be, but I'm not bound by that agreement. I could sentence you to anything that the law would allow and grant or deny early release as I see fit. Do you understand that?
yes,
Okay. And in fact, the maximum legal sentences are in the plea petition earlier here. They're right here. And it provides that you could be sentenced to up to 12 months in jail, a fine of $2,500, and then a post-imprisonment supervision of 12 months after that. You understand that that's the maximum sentence that anybody could get for this crime.
yes.
Okay. Has anybody promised you anything or pressured you to get you to plead guilty today?
No,
All right. Before I ask you how you plead, I want to know if you have any questions about anything that you and I have talked about or anything that you're wondering about before I ask you how you plead.
no,
All right. So given that to the count one of the information, which is DUI, third offense, how do you plead, guilty or not guilty?
I'm guilty.
All right. Ms. Whitman is going to tell us what she believes the facts at trial would be if this case went to trial. I want you to listen closely because when she's done, I'm going to ask you if that's what happened in this case, okay?
And I didn't see the paper, so I knew you were.
Mr. Hall, you understand that?
Yes,
Okay. Ms. Whitman, would you give us a factual basis, please?
Yes, Judge, on December 20th of 2017, just after midnight, officers observed a vehicle make a right turn to go west on Central Avenue. As it did so, it turned so wide that it went into the eastbound lanes of Central Avenue. The vehicle was eventually stopped and the driver was identified as Gary Hall. When they were visiting with him, they could detect a strong odor of alcoholic beverage coming from him. His eyes were extremely bloodshot, watery, and glazed. When he spoke, they had difficulty understanding him. His movements were sluggish and uncoordinated. He could barely stand on his own at the stop. He was requested to take a PBT. He tried to give a breath sample and was unable to do so. He was placed under arrest. He was read the administrative notices and requested to take a breath test, and he refused to take that test. Upon review of his driving record, he had 2 prior convictions for DUI, both out of municipal court, one April 28th of 2009, the other November 2nd of 2016. All these events occurred in Wyandotte County, Kansas.
All right. Mr. Hall, did you hear what the prosecutor had to say?
yes,
Is that what happened in this case?
yes,
All right, thank you, sir. I find that the defendant has freely, knowingly, and voluntarily waived his constitutional rights and entered his plea of guilty. The state has provided a sufficient factual basis for the plea. The defendant understands the nature of the charges and the consequences of the plea, and I will make a finding that he is in fact guilty. I'm going to order a pre-sentence investigation and defer sentencing upon the receipt of that. I was given a date by my administrative assistant. Ms. Whitman, Mr. Long, how does June 26th at 9 a.m. sound?
Work for me, Judge.
Just a second, Judge, the 20. At what time, Your Honor?
9 a.m.?
I can make that work.
Okay. All right. And Mr. Long, were you able to get a PSI request filled out?
Your Honor, I have it. I just need to get Mr. Hall's social security number, which I'm hopeful after this is not public any longer. You can just provide me and then I can scan that over to you right away.
Okay. All right. So I'm going to set sentencing June 26th at 9 a.m. and other things. Oh, I'm sorry. Mr. Hall, as a convicted felon, it's now prohibited for you to own or possess a firearm, certain kind of deadly cutting instruments like dirks, daggers, switchblades, stilettos, basically any kind of knife that could be considered a deadly weapon. Do you understand that?
Yes,
All right. With that, ladies and gentlemen, is there anything that I failed to cover today? Ms. Whitman?
I know of nothing, Judge.
Mr.
No, Your
Long?
Honor.
All right, then we're going to be adjourned. Let me stop the feed and I'll let you.